Good evening and welcome to the bench. I'm Keith Garvin. This is week 2 of giving you the inside track in the state versus Gerald Goines. Goines was a Houston police narcotics officer. He's accused of lying to get a no-knock search warrant to raid a home on Harding Street. The raid happened in January of 2019, killing Regina Nicholas, Dennis Tuttle, and their family dog. 4 officers were shot that day. Another one was injured. It's been a big day in the court with the prosecution resting its case. Tonight we have an all-new panel of expert legal analysts to walk us through it. We want to start off with KPRC2 investigates Mario Diaz. He's the bench-embedded reporter on the Goines trial. Next to him, Angela Welton, who has tried capital cases as a defense attorney and as a chief prosecutor for the Harris County District Attorney's Office. In the middle, Joe Venus, a former felony chief prosecutor in that same office. Joe has a specialty. He can dissect a search warrant, which we will talk about because of the Harding Street raid. And in between us is Leticia Quinones-Hollins. You'll remember her as our legal analyst on the bench during the Antonio A.J. Armstrong Jr. trial. Leticia, a defense attorney through and through, is really known as a defense attorney to the stars. We want to welcome each and every single one of you. Thanks for being here with us. Okay, Leticia, we want to start with you because you were early on, you were on Rusty Hardin's team representing one of the officers, Felipe Gallego, in the Harding Street raid. He was involved in that. Tell us your involvement first off and what happened while you worked on the case.
Certainly. I was one of the defense attorneys that represented one of the police officers who actually executed the search warrant on the Harding Street home. And he was charged originally with murder, and I believe one of the only officers charged with murder outside of Goines. And eventually that case was dropped, as it never should have been brought in the first place. And of course, I think once the prosecution got through the thick of things, they realized that those charges would not hold up with the jury. There was no way they would have been able to find this guy guilty beyond a reasonable doubt of murder, especially when he himself had no idea that that search warrant was fake.
Okay. Yeah. Let's get back to the trial right now and the happenings. Prosecutors, again, rested their case, think much faster than anyone expected. Before we get into what the state did, I want to talk about the defense for a second. Mario, to you first, they called a K-9 officer as their very first witness. What's the significance behind that?
Well, what they wanted to do at that point was examine whether or not there were actually any drugs inside the home. And they brought this K-9 officer in at about 2:45 in the morning following this deadly drug raid. And what this officer testified to was that she is separate from this narcotics squad. She brought in a dog that is a canine narcotics dog. They wanted to walk this dog around the house to see if they could find any drugs inside of the home. Why were they doing this? They wanted to identify whether or not this warrant was valid. That was the sole purpose for bringing in this officer. She testified it was hard to work around that house. As we have shown in the past, we've been inside the house. The Tuttles, Regina Nicholas, Dennis Tuttle, they were hoarders. So the house was completely stacked, making it difficult to send the dog in certain locations. She said it was dangerous because you don't know what the dog can come across in those kind of situations. But then, and this happened at about 3 o'clock today, it was the very first witness for the defense. They admitted she was subpoenaed. They brought her in. They wanted to bring in this witness. And then you had the state come back. Keaton Fort really hammered at the very end on the cross, said, so you were there specifically to examine the validity of this warrant. You weren't there to investigate the deaths of Dennis Tuttle and Regina Nicholas. You were there to examine whether or not this warrant was true. You were there to try to find drugs. That was the message he was trying to send at the very end.
Okay, before the state rested their case, they actually had some impactful and important testimony. Regina Nicholas's mother and brother testified. First to you, was that done to humanize her to the jury?
Sure. The state will always do this in a case where, especially a murder case, where the thinking is that the jury has a right to get to know the person who can't be there and speak for themselves. And so you don't want to just see them on paper. You don't want to see an autopsy report or even photos of them. What you do is almost always you bring in, and quite often it's the last witness for the state because it is so emotional and impactful to the jury. They'll bring in a family member, a close loved one, to really humanize, like you said, this person to the jury, so that the jury can connect with them and get in on that emotional level and understand just how important this is.
Keith, if I could jump in,
yes, please.
Should they do this at the very end? If you're trying to build the narrative and personalize the victims here, should it be done at the end or can it be done at the beginning?
I've done it at the beginning as well. It really kind of depends on your case. I do understand it in this part, though, because it had gotten so technical. Mm-hmm. We'd really been utilizing an expert on trajectory and bullets, and then he wanted to, I think, Keaton wanted to end with impact. Mm-hmm. The question is, was it successful? Right? We had one witness testify, not in person. And I do find that even though you may have to, from some circumstances, have a video ready, it's harder to connect with the juror.
Letitia, your thoughts?
Yeah, I was going to say, I think in this instance, it was better to do it at the end, and I'm going to tell you why. All the things that Angela said, but another reason is they heard a lot of evidence about these guys potentially using drugs, selling drugs. They heard a lot of things on cross-examination that painted the complainants in this case in a bad light.
Right.
And so the state had to let the jury know these were people. These were human beings. And so the last impression I want in that juror's mind is just how special these individuals were to their loved ones.
And Keith, so what they did to convey how special these people were was they brought in Dennis Tuttle's brother, Ron Tuttle, and they also had video testimony of Regina Nicholas's mother, Joanne Nicholas. You might recall we went out and visited her in Louisiana a couple years ago.
I do.
Joanna Nicholas, Tanisha Manning asked her the questions. It was a taped testimony agreed to by both sides, so that way there was no cross by the defense. And she basically talked the way you'd expect a mother near 90 years old would talk about her daughter. Sure. The memories, the great times that they had. She also admitted she hadn't visited her daughter in about 5 years. She had not been to the house on Harding Street. Then when she got off, they brought on Ron Tuttle. And Ron Tuttle is the brother of Dennis Tuttle. And what we heard from him was that, you know, and they showed a picture of them on their wedding day, which was the first time we saw this picture. So then you talk about that humanizing component. Then they talked to Ron Tuttle about his brother, and he said, you know, my brother, he suffered a major injury after he served in the Navy. He served for a couple of years in the early 80s, suffered a major back injury. Then he also talked about later on in life, he was a worker at the Goodyear plant here in Houston, suffered an incident where a ball bearing somehow caused a major injury to his head. And that's where you kind of start connecting the fact that he's been living with pain all these years and that he needed this kind of medication, or he needed medication, I should say, to help alleviate his pain. And they testified today about how he struggled with pain. That was the humanizing component that we saw at the very end from the state.
Are they going to have an opportunity to bring any of those witnesses back at the end, or is it too late? They get one shot?
Well, I think this is the end of the state's case. They've rested today, so they brought him in at the end. And kind of like what Angela and Letitia were saying, just another short way to put it, start strong, end strong. We had, like they said, days and days of this Texas Ranger up there who did a great job. I guess depends on who you are, who he did a good job for. But then you kind of circle back, bring it back to what the real point is. We got 2 people who are dead, a dog who's dead, and 4 officers injured, and it's a good way to do it.
But usually we see those victim impact statements when there's been a conviction, and we're talking about sentencing,
right?
Correct?
Yes,
Different,
on punishment,
different thing.
I would expect to see, at least Ron back.
And Ron was very humble. He said, "This is not what I'm used to." He told her, "I'm telling you the truth, ma'am." He was looking at the judge, looking up at her, at Veronica Nelson, and she was smiling at times. You could just tell that they didn't want to be here. We all understand nobody wants to be in there. But for them in particular, this is not something that they're used to.
We brought up the Ranger. We want to turn that to Texas Ranger Lieutenant Jeff Wolf, taking the hot seat three days this week. Going to break all that down. Mario, first off, the Rangers came in 6 months after this all took place.
They did. They came in around late July of 2019. And they came in because what happened was they had the raid. and everybody said this wasn't done properly. We ended up going inside the home in April of that year. We were the first ones inside. We could tell that there was a lot of evidence still inside that home, which was we chronicled as well as others as well. There was another media outlet. And then in early May of that year, you had the family's private forensic investigator. And we were there when they were collecting evidence, doing the trajectory rods, which are these long poles to kind of show how a bullet was flying into a home. So there was the pressure for the DA's office to say, what really happened here? Yeah. They went to the Texas Rangers, and then they brought the Texas Rangers in. This is Lieutenant Jeff Wolf. I saw him there. We actually connected. I said, hey, I don't know if you remember, I was there the day you were out there. He goes, yeah, I remember. And I remember him. A very, very effective witness. He's the type of witness you would love. Yes. He talks, and he talks to the facts.
Yes.
But at the same time, it's a witness that you might also not like in certain instances. You guys are laughing.
Well, I mean, he's the kind of guy, and I watched quite a bit of his testimony, actually walked up to him after court today, shook his hand and said, hey, man, you did a great job. And he's the kind of guy that, like you said, he's just going to talk about the facts. And if the facts hurt you, you're not going to get him off those facts. He's just going to, I mean, you want him, if he's bad for you, good for the other side, you ask as few questions as possible and get him out of there.
Yeah, Angela, we'll talk about that because he was brought in by the prosecutors to help their case, but then he ended up getting flipped by Goines' team. Talk about the risk in that and why they chose to do that. What are the benefits of that if you're going to flip a witness?
Absolutely. So the state calls him, and it was Max Seacrest who. It was a masterclass to watch him as he utilized this expert as if he was part of the defense. He really was able to get information from this expert that was aiding or helping his case. And a lot of that he was able to utilize statements of other officers that wouldn't have been able to testify. And he was able to get their statements in through this expert.
And I want to get Letitia's opinion on this because the way Angela's talking about flipping an expert, I'm going to give you the example. The day before, on day one, you had this lieutenant testify to everyone in the courtroom that he was able to pinpoint one bullet that they were able to pull out, connected to Dennis Tuttle. They pulled it out from the neck of Sidell Lovings. He's the officer that was paralyzed in this incident. As for the other bullets, he goes, well, you know, they got damaged. We weren't able to actually pinpoint and connect it to him. So you had Max Seacrest say, and this is where it gets the flipping part, say, you know, and he's looking at the document. So Dennis Tuttle shoots these 4 officers. And then later on you have him say, so these 4 officers are shot by Dennis Tuttle. And he continues to, as you said, testify on behalf of the defense with the phrasing of the questions. That's what we saw, Letitia, in terms of the flip. Can you speak to that strategy?
Absolutely. So what I always say, even when I was a professor of trial advocacy, trial is an art. You know, you never want to walk in there just as a lawyer, you know, who speaks lawyerly. It's an art. You must remember that those 12 folks in the jury are human beings, and you want to get inside their heads. That's your whole reason for being there, and that's exactly what he did. So when he sat down, what they remembered was that it was Tuttle who shot the gun that caused Lovings to be a paraplegic. And you must remember this, if they dismiss Gallego's case, that means that there was significant action by the Tuttles that gave him reason to pull the trigger. And so all Mac did was highlight that and remove the doubt, created the doubt, but remove the culpability or the fault from Goines.
And the key word was dominant. A dominant position was used.
Yeah.
Angela?
Yes, I was always curious. What is the defense going to say about Regina Nicholas? She didn't have a gun on her. She was near the couch. How are they going to say that was a justified shooting? And I could see that Mac utilized this expert by using certain terms, like she was in a dominant position because she was standing as opposed to sitting. And in that dominant position, then the officers would need to then watch out for her, or that she was at a risk to them. And he even got the expert to say that a reenactment with her, where if she was leaned over and Medina was on the couch having been shot and she was leaning over him as if she was going to grab his gun,
Right.
would that been possible to show how she was shot?
Okay.
And the dominant position, Keith, if you think about it, it's simply standing up. So if Regina Nicholas is on a couch, it's suddenly you have your door broken. What's this?
Most
you might
people
get
jump
up, and you're
up,
like,
yes,
and you
yeah.
might lean forward. And what they didn't prove was that she never actually held a gun. She never. That was the key point. Like, did she ever pick up the gun? Did she ever?
Well, the defense had to make them the threat. They had to do
They
that.
turned them into defendants.
Exactly. They turned them into defendants by making them the threat, therefore creating a reason as to why those police officers actually shot them.
Yeah.
Because they were the ones that were the threat. Because normally, when you execute a no-knock search warrant, no one is really shot, right? So something happened inside of there that took it from just your regular no-knock search warrant to an actual killing.
Keith,
or
you were
homicide.
there that night.
I was, yes.
You covered that very closely. You remember the days after. You were there. Everybody was saying these were homeowners. And now they're being turned into defendants.
Absolutely.
I think everyone's in agreement here.
Sure.
They were being turned into defendants
Right.
after being victims to everybody over the course of 5 years. That's what the defense has done. But the state did have one good moment. We have a graphic about, no, I wouldn't say one good moment. It's not fair. They had their moments, okay? They had their moments. They had their moments. It's not fair to say it like that. But they had this moment. We have a graphic. This was a really powerful moment where they showed the chamber of the revolver,
Right,
okay?
I remember
and this
day,
is the
yes.
typical revolver, and I want to show how a revolver has markings. So you see 3 bullets are marked right here on the bottom. Then the 2 on the side that aren't marked, that's technically a skip according to what the prosecution was trying to get, and they got the Ranger. So that 1 bullet right there, well, the Ranger testified that bullet could have been fired on a different day, at a different time. Now, this isn't what the prosecution didn't say. In my humble opinion, they could have come back and said, well, couldn't you also say that those 3 other bullets could have been fired on a different day, on a different time? Remember, he only testified that they pulled. You're smiling, but they didn't say it like that. They admitted that that 1 bullet may have not been fired. To Keaton's defense, to Tanisha Manning's defense, they're the prosecutors. They said initially, hey, he may have fired up to 4 shots. So if you're creating that doubt that he may have fired, they had surrendered the fact that he did fire 3 by saying that that other one could have been shot on a different day.
Let's talk about the jurors real quick. You saw them; they were taking notes today. What kind of feel did you get from the jurors?
They're very attentive. I think the attorneys can examine that more because of the fact that I look at you and I take notes. We go to a story, we're on our phones taking notes. We know what we're going to do. Now imagine if we have 8 other reporters right beside us and now we're comparing notes. And that's where that can become tricky in the jury room.
So, Joe, you as a former prosecutor, when you see jurors taking notes, what's going through your mind?
Well, hopefully they're taking notes when I want them to take notes. If I've done something I feel is great and they're writing it down, I'm feeling good about myself. If you have, the Picasso of trial art like Max Seacrest sitting over there and he's making point after point and they're writing it down, that's not a good thing. Yeah. But the important thing about these notes is that they're taking them as this testimony is going on live and watching them, talking about the attentiveness of the jurors. There are several monitors around the courtroom. And when I was in there today, I could see all the jurors facing in different directions because they were each watching the monitor that they had the best vantage point of. So they were clearly focused on the evidence that was being presented. And they were taking notes they were just, there's 16 of them, so they have 4 alternates is what it looks like. And they're all doing a really good job. And if you remember, they picked this jury a little differently than we normally do. They picked it a few months ago, went through the whole jury selection process and treated it like it was a death penalty capital murder case because of all the publicity and things. And so it took them a long time. And just from what I was seeing today, especially, and noticing in the courtroom, was that it appears that everybody, the judge, the defense, and the state did a really good job of kind of ferreting out the people that aren't really going to pay attention, because everybody looked really, really focused in that box.
And a very diverse, you indicate.
Extremely diverse. So you had, I was looking at them. There's 16 in there, 8 men, 8 women, just every different racial composition you could think of. Interestingly, they all looked probably in their 30s or older, so they got rid of all the really young-looking people, which is probably a good thing.
There's a few experienced individuals in there.
Right. There's some gray hair on the box,
yes, exactly.
Which is a good thing in this case for both sides, because sometimes if you feel like you're going into a case and you don't have much of a case, you might want some people who are, might drift off and not pay attention. But I think in this case, both sides want people to pay attention, and that looks like they got that.
And that's what it's about. They don't share their notes at the end. They don't take them back. This is for them to be able to pay attention and organize their thoughts. That's the purpose.
Internalize some of the things that they remember, right? Because they don't get to take it back. Some of us have photographic memories, so as you write things down, you'll take a mental picture of what you wrote down. Sometimes that's better than just remembering what you heard. Right. And so for the most part, that's what those notes are for. It helps you commit the facts that are important to you to memory, so that when you can go back, no, I wrote this down, I remember that. Now, of course, everybody's going to hear things differently in a trial, and that's why they don't let the notes come back.
Yeah. You know what was intriguing? Remember a week ago, or when this trial first started, the day after, we were like, this might be bumpy, Keith, because of the fact that they booted one of the jurors.
That's right, I remember that, yeah.
And we're thinking, are they going to have enough jurors to actually get through this if they're already booting one like immediately the very next morning? But ever since then, it's been very smooth. All of them, as you guys have indicated, very, very engaged.
Yes. Okay.
Well, this case, it's hard not to be engaged, to be perfectly honest.
This is true.
It will keep your attention, most definitely, yes.
Yeah, I call these cases sexy. This is a sexy case, and everybody pays attention to sexy things.
Okay, all right. With that note, we're going to take a quick pause in the discussion. Right here, we're going to go ahead and take a break. Coming up after the break, we're going to talk about Dennis and Regina's dog that was killed. And also, because it's the defense's turn, we want our experts to weigh in. Does Gerald Goines take the stand? All that and more next on our live coverage of The Bench. All right, welcome back to The Bench, our way of bringing you into the cameraless courtroom for the trial of Gerald Goines. He's a former Houston police narcotics officer accused of lying to get a no-knock search warrant and raid Dennis Tuttle and Regina Nicholas's home. Important to talk about Regina Nicholas and Dennis Tuttle's dog Star. During opening statements, the prosecutor said the two were dog lovers, and if you knew them, you would know that about them. They argued Goines did not know that they had dogs, 3 in fact. When he found out, he ordered officers to kill those dogs. Actually, I think he did know. They said that he did know that they had dogs. Mario, you got this video that we're going to look at in just a moment. It wasn't until this week that we knew what it was about. Let's roll it and listen. Okay. You heard 2 shots there. Mario, tell us what you learned in court about that.
Okay, so when we first got this video back in 2019, we were under the impression this happened later than the shooting. We knew that, right? It happened about 3 minutes and 35 seconds after the raid. The initial video was like, all right, 2 minutes and something, because the person was grabbing their phone to try to grab it and see what was going on. So you have the raid go down. You have everybody shooting in different directions. The Tuttles are believed to be dead at this point. Everyone's wondering why these 2 shots so many minutes after this raid. And it was testified in court by the Texas Ranger that from his investigation and his understanding, what happened was, so this dog, they knew about the dogs. I don't think the order was completely given. They did know about the dogs being inside the house. But they said they were caught off guard by this dog that still came after them as they, kicked the door in. Suddenly you have a dog coming up to you. So the third officer in the stack, it's called, that's all the officers going in. The third officer was Sidell Lovings. He fires a shot at the dog. By that point, Officer Medina, who was the second one, was inside the house. Stephen Bryant, Goines' partner, had already rammed the door in. So Medina's inside the house. He goes to the left. He's pointing at Nicholas, according to the testimony. He hears the gunshot, looks at the dog. He turns and he fires at the dog. So now we got 2 shotguns into the dog. So then the raid happens, everybody's shot, these officers are recovering, and you hear these bullets, and the ranger says that what took place was that the dog suddenly started coming back to life. It started growling, and it started to stand up, and then that's when a different officer goes and fires the 2 shots.
Those are those 2 shots we heard.
Yeah, and the immediate question I had was, hey, was a necropsy done? Did they do any kind of autopsy on the dog? Because you want to go see, did they pull bullets out of that? Appears that they never did. And the other question about this was, Now, how does that really happen? I spoke to a professional dog trainer of police dogs yesterday, someone who I've known for several years. He has trained dogs all over the place. He said, Mario, dogs are extremely resilient. He brought up his point that he was in Iraq. They had a Humvee flip. The driver died. Technician was a vegetable after that. The dog handler and the dog handler got staples. The dog got a bloody nose. He said dogs are very resilient. He goes, think of stories where you hear a raccoon getting shot 4 or 5 times and it doesn't die. Dogs can do that. So he said, I'm not really too surprised by what took place there. Joe's serious about this one because you've had a point on this from the very beginning.
Yeah, talk more about the search warrant, and isn't that something that the judge would have known or should have known, that there were 3 dogs in the house when they asked for the warrant?
Well, so when you get a no-knock warrant, and it's important to note that HPD has completely changed their policy on this because of this case. Now you have to have specific officers go and execute these no-knock warrants. They have to be signed off by the chief of police, and instead of going to just any judge, you have to go to a district court judge, just like Judge Nelson, somebody who hears felony cases, somebody who's presumably more experienced and deals with these things a lot more. And so in order to justify a no-knock warrant, you've got to put into the application or the affidavit supporting the warrant factors that you feel are dangerous to justify. They're known to carry a firearm, which that was brought up today in court under the ranger's testimony, that it said that Tuttle was known to carry a 9mm. And they talked about, you can also talk about, you feel like there are factors that will cause evidence to be destroyed.
Should the dogs be mentioned in the warrant?
Yes, and I'm getting, sorry Mario, I'm getting there. Yeah, I mean, if you're going in and you think that there are dangerous animals, they keep 7 pit bulls right by the door and they don't feed them enough, yeah, you want to put that in the warrant. By the way, Judge, this is another thing that if we knock on that door, these dogs are going to alert the homeowners, and be, potentially agitated by our presence. So you would think that that would go into the warrant.
I don't think we ever heard that a dog was attacking or attacked somebody.
Correct.
And when we say the dog, Star. The dog is named Star. And Star didn't do anything to get his death penalty in this situation. Is there not a different circumstance when there's a dog in the house?
Well, and a dog's going to defend its owner.
Well, not just that. My dog, I mean, you hear somebody closes, the across the street neighbors close their car door. He's up barking and running to the door. He's never bitten anything in his life. He wants to go smell you and lick you and make you pet him. And so I've thought about that, especially after this case. If somebody comes and bangs my door in, my dog is gone before and nothing I say is going to stop him. He's excited. And that can look like aggression, and he doesn't deserve to get killed.
Well,
so
I come from a different point of view in that I somewhat was tied to this case. And there was evidence to suggest that the dog had become aggressive. And so they had to alleviate the threat of the dog.
But what was it? What was the aggressive act?
Standing up and growling and in an attack mode.
Right. But
Yeah.
Letitia, can you understand how Houstonians would have doubt with that story,
Absolutely.
considering that the warrant, by all accounts, was fraudulent?
Oh, absolutely. I don't take anything away from that. I think that we must not lose sight, though. Other than Goines and Bryant, the rest of those police officers had no idea that the search warrant was fraudulent.
Right.
So those 4 gentlemen, that was the ones that were in the stack, the 4, they had no idea.
And you got to remember, Bryant was because of after the fact for helping Goines.
Right.
It
Yes.
wasn't before. It was after the fact for going in and getting the drugs of Goines, who obviously is the man at the center of this as the defense, Keith, starts to make its case.
Okay, yeah, so we want to talk about that defense making its case, about to start its case. 2 big questions. One, do we think they're going to wrap up by Friday? And then the second question, is Gerald Goines going to take the stand?
Well,
Who wants to go first on that?
I think if the answer to your first question is they wrap up by Friday, the answer to the second question has to be no. He doesn't testify.
And I think it is a definite no, because the defense team, Max Seacrest and Nicole DeBoard, thank you, mentioned to the judge, hey, it's conceivable we can wrap things up by Friday. Listen, if Gerald Goines is going to go on the stand, they're not going to wrap up on Friday. That prosecution is going to have him on that stand for at least 3 days, just grilling him. Letitia, you're like smiling.
Would you put him on the stand?
Absolutely not. There's no advantage. No way Gerald Goines get on the stand. They don't win anything.
But let me ask this question, and we've talked about this. Let me ask this question, and I think this is an important point that the prosecution might be hammering in on the closing arguments. Gerald Goines is a different type of person going on the stand.
Absolutely.
If he turns them down, you have a member of the Houston Police Department not wanting to address the public, these jurors, about his actions. It's not a regular defendant. It's a police officer whose career and life is on the line. Does that make it different in the eyes of the jury that the police officer doesn't go to the stand?
2 points about that, I think. One, first of all, the prosecution better not hammer on that point. Otherwise, we're doing this whole thing all over again.
Fifth Amendment right.
They cannot comment on it. Second of all, I think what's important to know is that if he doesn't testify, and I think we're all unanimous in that he's not going to testify, then I think it lets our potential juror pool know that if you have a seasoned narcotics officer who is up there fighting for freedom for the rest of his life, if he doesn't testify, then I think it makes it more understandable when future jurors walk into the courtroom to understand why, as you call it, a regular defendant wouldn't want to testify and subject themselves to the rigors of cross-examination that, I've seen Keaton firsthand in a murder trial cross-examine people. He's good. He's real good. And so if Goines doesn't take the stand, and I don't think he will, then I think it's important for people to remember, look, this is the same right that everybody is afforded. And if this guy who's been on the force for decades won't do it, then there's a good reason for lots of people not to.
But does it send a different message to the jury?
It does, but
yes.
This is where voir dire comes in, okay? And so in voir dire, that is the defense attorney or any attorney, prosecution or defense. That's our opportunity to educate the jury about certain issues such as these. And in this type of situation, what you want to educate that jury with is that human, your human instinct is, I want to hear from the defendant. I certainly want to hear from this seasoned narcotics officer. That is a natural feeling. But even though you want to hear from him and you don't, you can't consider that. And
Exactly.
That's the law. And so during voir dire, that's where you're asking. And in this instance, I would ask each one of those potential jurors, will you be able to put those feelings aside and be able to render a verdict without utilizing that information?
Yeah, I was going to mention, speaking of natural feelings, I think most people who are at home, eating popcorn, watching the trial, or listening to the trial, they would think, my goodness, if I'm ever on trial and I know I didn't do anything, I'm going to testify because I want the world to know.
Absolutely.
But why, from your perspective, why would you not want?
And I want to know. I
Yeah.
want to know what the motive is and what was going on in his head and why he needed to push this so quickly and with the false information. But the bottom line is, it doesn't matter somewhat doesn't matter. I think he's going to have to fall on the sword the defense already has with regard to he has lied in this search warrant. I think we'll hear from him at punishment.
Oh, okay.
I think we will hear from him, but not at this stage. It's too risky to the defense.
How many
Assuming we get there.
Assuming we get there. How many punishments will be? There's two charges here, right?
Yeah. Okay. Oh, please, Joe, go ahead.
Oh, no, I'm good.
Okay, so defense wraps up. If they wrap up tomorrow, what would you like to hear in the closing arguments? Angela, we'll start with you.
In closing arguments, I think what I would expect from the state is that they are going to come strong with, but for Gerald Goines' actions of getting them to that door, right? But for him requiring them to do a no-knock, that every single officer there would be well. They would not have been shot, and that the lives of two people and of Starr would still be here. And because he took extra steps to get them there, right? Getting the tactical unit together, talking to them about it, making sure this was a no-knock, a surprise warrant, then that's why they want to have the felony guilty on a murder. But that's a long way to go. On the defense side, they're going to focus on what happened in that house. They've already came on super strong in opening statements, putting the Tuttle and Miss Nicholas at trial. They are saying their actions is what caused their own death. And I thought originally that was a bit overreaching. But I will tell you, with the expert and the way that the defense has utilized
Lieutenant Jeff Wolf for the Texas Rangers.
Absolutely. This ranger, the defense was really able to kind of show what happened within that house. If the jury is thinking only what happened in the house, they may be thinking the officers were justified in their shootings.
Joe?
Kind of playing off what Angela said, I mean, that's your 30,000-foot view. That's what you want them to do. It's important to note that just because of the procedural rules, the state can go first, but I doubt they do. They might say something a little just to kind of set the table, and then they'll sit down and let the defense do everything that they're going to do. The defense gets one shot, and I expect they will do more of what they've done. And you're looking at two of the best lawyers I've ever seen. Mac was my professor in law school, also Angela's. So we've known this guy for over 20 years. And I mean, he's just a rock star. And same thing with Nicole. She is fantastic. And so I expect them to get up and make a very good argument about what happened inside that house. And like Angela said, criminalizing what the victims went through and putting the blame on them. That's where I think they have to go. When the state comes up behind them and has the last word, what they need to do, I think, is kind of what we were talking about earlier when they flipped Lieutenant Wolf or Ranger Wolf for the defense, get that back. Talk about how, and they talked about this in court today, how Regina Nichols' DNA was not on any gun. There's no evidence that she ever possessed, touched, nothing. Didn't have a gun ever. So why is she dead? And start off with that kind of in argument. They didn't do this that I saw on any testimony in court. So maybe they're saving it for argument. Bring that back now when the defense cannot respond to it, and bring him back to their witness. Then, as Angela was saying, go back into, but for this officer, Letitia's client, not in the same position. None of the officers in the same position. This officer, this officer, Gerald Goines, is the root cause of all of this. And I would, because as we talked about in kind of the pretrial interviews about why it's so difficult to convict a police officer of a crime, not just focus on Mr. Tuttle and Ms. Nichols and Starr, but also really focus in on, but for him, you'd have 4 police officers who don't get shot. Exactly. And that makes the jury feel better about convicting a police officer, because not only did they kill 2 people and a dog, now they've also hurt 4 cops.
Letitia, what if closing arguments tomorrow? What would you like to hear?
With the state, I think in this instance, they have one of the unique situations where they can actually marry the law with the facts in this case, and it works perfectly for them, in my opinion. And that the law that the jury will be charged with, the judge is going to read the jury charge to them, which is going to be the applicable law in this case. And it's going to be whether or not Goines performed an act that was clearly dangerous to human life, right? I would remind the jury of that if I'm the state. And what is the act that he performed that was clearly dangerous? And that is, he created a fake search warrant that caused an execution by the SWAT team of a no-knock warrant with guns, right? And in that search warrant, he warned those police officers, the SWAT officers, and I would use that. You know how you talked about Mac, who he used those terms? I would remind
narcotics
them,
officers.
Yeah, that these were not just regular patrol officers, these were SWAT officers.
Felipe Gallegos, her former client, actually was promoted to SWAT.
That's right.
In the days before this raid. That's why he was left in the back of the stack.
That's right.
Because they did not want him to be injured in any way, because he finally got to a place with an HPD that had been a goal of his.
That's right.
So they
his entire life. That was his goal.
Even though these were narcotics officers, and that's why Letitia's saying SWAT officers, because he was promoted to go to SWAT.
That's right. Okay. And so what Goines did was cause SWAT officers armed with very dangerous guns to go inside of a house with a man with a gun as well as a dangerous dog. So this is the mindset that Goines created. That's the act that he committed that was clearly dangerous to human life.
In my personal opinion, again, I do what I do. You guys do beautifully what you do. But I would go inside the house and I would bring out the gun battle. But I would say that The bullet, these individuals were portrayed as defendants, but the bullet that Dennis Tuttle allegedly fired, according to the witnesses, and that hit a police officer, that bullet was actually caused by the defendant. The police officer that was paralyzed for life was caused by the defendant. And play exactly to the point. Take them inside to the to the shootout. Yeah. Take them there and make them reverse the position. Dennis Tuttle's not a defendant here. Dennis Tuttle would have never fired a gun that shot that police officer. The defendant is the one, his actions caused Dennis Tuttle to fire a gun that ended up hurting one of their police officers, that paralyzed their police officer.
And to your point, Mario, remember, in the mind of the Tuttles, they hadn't done anything wrong.
Right.
The search warrant was fake. Right. And so they're sitting there in their home on a regular afternoon, morning, what have you, and all of a sudden someone's busting through their door with guns. Well, self-preservation is our first instinct. And so because they're sitting there and they fire a weapon at something like that, that's not Tuttle's fault. That's Goines' fault. And if I was the state, that's what I would harp on. And then much like they said, if I was the defense, what I would harp on is the fact that there are search warrants executed all the time. Yeah. And rarely are people shooting at the police as they come through the door.
And you're going to hear a lot about Lieutenant Walker's testimony and what he said and how he agreed. And he agreed with the testimony of all the officers inside of that home.
Okay. Yeah. All right, our panel, excellent. Letitia, Joe, Angela, thank you so much. Mario, you're going to be, great job by you as well. You're going to be in the I don't want to leave you out.
Quick plug, we have an entire team here. It's not just myself. We have Nifa Saavedra. If you haven't been watching the blog, if you haven't been catching up on it, every single minute we have Nifa inside the courtroom. We're sitting together. We're documenting this trial because we understand this impacts the community. This impacts our trust in law enforcement at the end of the day. It's been a big case. You can follow it at any time as it's playing out. The bench, Gerald Goines, click2houston.com.
Okay, tomorrow's going to be another big day. Again, thanks so much to our panel.
Thank you.
All right, remember, we're going to continue to bring you minute-by-minute updates from the courtroom on click2houston.com. Just click on the bench section on the homepage. There you're going to also find everything else that you need to know about this trial. For the bench team, thank you and good night.
Good night.
Good night.